non-legal topics. In today's episode, we're going to be talking about a matter that is complex and difficult, bankruptcy. At Morejon Attorney PA, we practice bankruptcy, and I can tell you, even as a practicing attorney, that is one of the most challenging areas of law. If it's not the most difficult one, we say that for tax law, but it's very technical and potentially difficult to work. For today's episode, I invited my good friend, work colleague, and past boss, Paul Meadows. Mr. Meadows has been a practicing attorney in the state of Florida for over 10 years. His firm, Fidelis Law, specializes in bankruptcy and foreclosure cases, and they also handle family, probate, and immigration. Hi, Paul. How are you today?
I'm doing well. And everything that concerns the law in one way or another ends up being complex, difficult, intricate, whatever word you want to use. But yes, my name is Paul Meadows. My firm's name is Fidelis Law. And I practice primarily bankruptcy and debt settlement law, trying to get you out of debt. In addition to that, as you mentioned, it's also immigration. I also do family, probate, and foreclosure and some civil actions too.
That's a lot.
It's a few. There's a lot of areas of law.
That's a lot. Thank you so much for being here today and for squeezing us in your very busy agenda, as we can see. So I really appreciate you taking your time to talk.
No, thanks for having me.
To talk about bankruptcy today. So let's start easy. Let's just go with the basics. What made you decide to become an attorney?
Well, it's really a personal matter, but my parents' divorce, I guess, had a psychological, emotional impact on me. And I saw what the law can do and what it can't do. But that's where I got started as an attorney. Now the question is, why did I get into the practice area of bankruptcy, which, as you mentioned earlier, is kind of dry, but not as dry as tax law, which I don't do. That's a little too boring for my taste.
Our next guest is going to be a tax lawyer, so we don't talk that bad about it because he's not going to like that.
I just said it's boring. I didn't say it was not important, but I find it boring in my unprofessional opinion.
All right, but you dig in my next question. Why you chose bankruptcy and foreclosure as your main area of practice?
Well, not so personal, but I have found that many individuals in Miami-Dade County and Broward, where I practice primarily, bankruptcy law, cannot understand for some reason that you should not spend more than you make. I see people do this, a lot of people do this every single day, okay? And unfortunately, when you spend more than you make, inevitably, there's a shortfall, and that shortfall is called massive amounts of debt. Now, my job typically is to get the honest debtor. Guess what? Debtor, that's a legal term. For someone, guess what? A debtor is someone that owes debts. So that the honest debtor can get a fresh start and can continue their journey of hopefully not making the same mistakes and doing the same mistakes again, but a fresh start, eliminating or reducing debt. Sometimes you can't get rid of all of it. Sometimes it's just not possible. But that's my job, to get the person out of as much debt as bankruptcy law will allow.
Okay.
And there's a lot of bankruptcy law.
Yeah, I know, it's complex and difficult, like I mentioned.
Complex and difficult.
I mean, one of the areas that we practice here at Morejon Attorney PA is actually bankruptcy law, and I find it very challenging and difficult to work with, especially because of the type of client. So, you just explain a little bit about what you do. So now, let's explain to people who are listening who are not attorneys, how does the bankruptcy work? So what is the basic in the bankruptcy? And you need to explain this to someone who's not an attorney and does not know the legal terms, so try to make it as simple as possible.
I'm going to try. because sometimes, I get into the technicalities and then that just creates more questions, et cetera, et cetera. I'm going to try to explain it like Denzel Washington did when he played the lawyer in Philadelphia. I don't know if anybody knows that movie, but he basically tells the individual when he asking a doctor to please explain it to him, the lawyer, this medical terminology as if he were a 3-year-old child.
Okay, but I need to explain it like a 3-year-old child.
Okay, I misquoted. It's actually third grader.
Third grader.
That's
Okay,
third grader.
Third grader sounds good. Okay.
Around there. Okay, so I'm gonna just start or primarily focus on consumer bankruptcy law. We're not gonna get into too much business-related bankruptcy law. We're gonna do primarily consumer individual law, which is mainly composed of Chapter 7 bankruptcy, everybody's heard of Chapter 7, and Chapter 13 bankruptcy, which is its bigger brother. The main difference, really, the main difference between the two chapters of bankruptcy is whether or not you make, on paper, you make more than you actually, than your expenses are. Okay, so generally, if if you as an individual makes less money than you are spending, then I would concentrate more on seeing whether or not you can get some debt relief in the fast and hard and what's supposed to be straightforward Chapter 7. If you are a wage earner that makes, a little bit to a lot more than your actual monthly expenses are, then you're actually under most circumstances, you must do a Chapter 13 because you won't, if you make even $1 over what you spend, then Chapter 7, you will not qualify for a Chapter 7. So, I can start with the fast and what is simpler, Chapter 7, or we can do the Chapter 13.
Before you jump into that, you mentioned income requirements. And that's a very common question with my clients. It's like, do I need to have a minimum income or a maximum income to apply for bankruptcy? And I'm sure you have heard this with your clients as well. Do you need a minimum income or a maximum income in order to file for bankruptcy?
No, realistically, and this is in generalities, there's a lot of complexity to all this. But in general, if you make less than what you are spending on a monthly basis, then you can do a Chapter 7. If you make more than what you spend on a monthly basis, then you must go into Chapter 13. Simply because if you have anything to pay your creditors, or you have any what's called disposable income to pay your creditors, then you have to do it in a repayment plan in a Chapter 13 setting. So there is no minimum, there's really no minimum, there's really no maximum. It's really what your income is versus your expenses on a monthly basis. Related, actually I get asked more like, is the amount of debt that I have good enough for a Chapter 7 or a Chapter 13?
Yeah, that's gonna be one of my questions. Like,
that's normally the more common.
Let's just put a pause on that and then just go back to it, because I want to go back to your previous answer when you were explaining the main difference between a Chapter 7 and a Chapter 13. So just give us a small background on how a Chapter 7 works, and then a small background on how a Chapter 13 works as well. So what do you do when you file for Chapter 7?
Very briefly. A Chapter 7 is a basic trade-off between you, the court, and the creditors that you owe money to. Okay? In a Chapter 7, in exchange for the elimination, or what's called a discharge, the elimination or discharge of all your dischargeable debt, because mind you, not all debt is dischargeable. For example, most student loans are not dischargeable in bankruptcy. You must have a hardship to discharge student loans, and we're not going to get into the complexities or the intricacies of that right now. But in a Chapter 7, to eliminate all your dischargeable debt, you must turn over or pay for all of your non-exempt property. What is non-exempt property? Non-exempt property is any property that is not exempt. You see, we're going in a circle here. In most cases, for example, if you own a home, you're only allowed to keep $1,000, only $1,000 of personal property, and $1,000 of vehicle equity. Those are your basic exemptions. You can keep that, they're exempt. Any property, if you have property over these values, you either have to pay the difference to the court, or you gotta give everything to the court for the court to sell it, and then pay out, whatever the stuff sells for to your creditors, so they get, a little piece of whatever you got that can be taken. So, as you can see, this can get very dangerous if you don't know what you're doing. Actually, most of my cases, most of the time, I consult with the client for 30 minutes to an hour to know exactly what property that person has, because in most cases, once you launch a Chapter 7, it's sometimes hard to get out of it. That's not what in a Chapter 13, it's much easier, but we'll get to that soon. So once you start a Chapter 7, you better know everything, all your financial circumstances and how that's going to impact your bankruptcy before you even file it. I know what's going to happen in my client's Chapter 7 if they're honest with me, which, sometimes I'm not told everything. But if there's full, complete, and truthful disclosure, I really know what's going to happen. And my clients end up not having to give away anything to the court because they're fully aware of what's going to happen, what's going to be taken, what's not going to be taken, what they may have to pay, etc., etc. So the planning stage of any bankruptcy is more important than actually what happens during the Chapter 7 bankruptcy.
Yeah, obviously, whenever I sit down with my clients, preparation is very, and truthfulness, that's the most important part, because some clients will not disclose all their assets, and then complete, full, accurate, truthful, all these words are important. If someone you have to be truthful with is your attorney.
Yeah, because we can't say anything. In theory, we can't say much now, can we?
No, we cannot. Attorney-client privilege.
Confidential.
Yeah, everything is confidential. So whatever you tell us, it's gonna stay with us. Not even with partners we can discuss this. So, but yes, preparation.
No names.
Preparation before the actual filing of the bankruptcy is the key process of the bankruptcy. So you already explained to us how the Chapter 7 works. Now you are going to explain to us briefly again, because I know, and you might think this is easy the way that Paul is explaining it, because Mr. Meadows is doing an amazing job explaining this to us in a very simple way, but it's not. So
there's a lot more than what is being told here. There is a lot more that goes into it. Remember, these are just in general. There is exceptions upon exceptions to everything contained within the law.
Each case is different.
Yes.
And then you listen to someone, my cousin filed for bankruptcy and everything is fine. Why I cannot do this? Maybe because you have more assets. That's why you cannot go the same route. Or,
as we say, the devil truly is in the details when it comes to, and those details should be known, all of them, before ever filing, at least for Chapter 7, where it's hard to get out of.
Yes. So right now, you're going to explain us how the Chapter 13 works.
All right, so a Chapter 13 works essentially if you have an income and that income is greater than your monthly expenses, and you can afford to pay something on a monthly basis to your creditors for a period of about 3 to 5 years, you get to make your own plan in a Chapter 13 bankruptcy that pretty much dictates how your creditors are going to get paid. And also, depending on what type of creditor it is, you make provisions for each different type of creditor. Chapter 13 bankruptcy is often called a wage earner's plan. You know, someone who has a salary or a business. But you don't have to be a salaried employee or a business owner to do a Chapter 13. People with Social Security checks, which is considered unearned income, can file for Chapter 13. That's fine. But there should be some disposable income available to pay for things and creditors through your Chapter 13 plan, which, as I said, must last between 3 to 5 years, in between 3 to 5 years. You get to do a lot more with a Chapter 13, where the main objective in a Chapter 7 is to just, eliminate all your debt. In a Chapter 13, it's what's fancifully called a reorganization bankruptcy. That means it's more useful for individuals that, we want to eliminate debt, but we also want to try to work out a repayment plan with, for example, mortgage companies, or with the financing company for a car, where you've fallen behind on your monthly payments and you want to come back, you want to cure yourself, which is come to date with your payments. So you can do a lot more with a Chapter 13 with respect to how you reorganize and pay off your debts. And you can also do a lot more with it in that if you want to stop making your payments, or you don't want to be in this bankruptcy anymore, guess what? You can tell the court in a one-page paper, I'm going to just stop this and I'm getting out of this. I don't want to do it anymore. That does not apply with a Chapter 7. You need court approval to get out of a Chapter 7. So it's dangerous because they don't always give you that approval. Chapter 13, as I said, you get to create your own little plan. You decide who gets paid, each category of creditor, what they get paid, and how it's going to be paid for a term of 3 to 5 years. And you can cure what's called curing and maintaining certain secured debt, which is basically any debt that is secured by property, such as a house or a car, and how you can come up to date with your payments on those. You can even take care of priority debts, such as the IRS. Actually, you have to. If you want your plan to get approved, you gotta pay the IRS under many circumstances. In some, you don't, but they are considered a priority debt. So you can do a lot more with a Chapter 13, and more importantly, you can get out of it if things don't go your way without too much of a hassle.
What happened, explain to us, if it's possible, if you filed for a Chapter 7, what happened if you realized, oh no, this is not the chapter that I should have filed for? Do you need to dismiss? Can you convert? Explain to us how that works and if it's possible to do that.
Luckily, you can convert. You can actually, without having to dismiss your own case, you can very readily, very easily actually convert from a Chapter 7 to a Chapter 13 without too much confrontation with the court or any of the creditors. The only thing is that under many circumstances, there will be a little provision in the order converting your case from a 7 to a 13 that basically says, if for whatever reason you can't complete your 13, you're coming back to the Chapter 7. Okay. It's not going to automatically dismiss the case. So that's why I say you better know what you're doing before you file something.
Right.
Now, from a Chapter 13, the same way you can, with a one-page piece of paper, you can convert a 13 to a 7. That's not a big issue. they'll let you do it. But beware, make sure you know, again, what you're doing.
Yep, again.
Because Chapter 7s are dangerous. Can be very bad.
So what we're going to do right now, since you already explained all this to us and we have a notion on how this works and how we are going to proceed, we are going to be answering a few general questions from our clients. So a few of you have gone online and sent those questions for us to answer, so we're going to try to do our best. These were the most popular ones. So, heading the number one spot of questions is, how does a bankruptcy affect my credit?
Well, the moment you file for a bankruptcy, your credit's going to be destroyed. Literally the moment that you file for bankruptcy, the credit bureaus get that information pretty much automatically. And everyone's going to know from your credit report that you have filed for bankruptcy. That will automatically destroy your credit score, and that will remain on your credit report for at least 8 years. It doesn't even matter if you complete it or rather dismiss it and nothing happens, you don't complete your bankruptcy. It will still appear on your credit report that you filed for bankruptcy.
So as soon as you file, that's it. It just goes on your credit
All
report.
bureaus.
It doesn't matter if you complete it or not. If you
Correct.
dismiss it, it's still there in the
It's still
record,
there.
and it's going to stay there for a minimum of 8 years.
Yes,
Okay.
8 years.
All right. So, what about getting credit cards or loans after you finish with your bankruptcy? Do
Well-
you get them? Can you apply for them?
Interestingly enough, the way it works in practice, although it probably shouldn't, is yes, once you file for bankruptcy, any chapter, as a matter of fact, within about, I've seen some clients actually get offers within 3 months, which actually surprises me. But in about 6 months, you're going to get some offers in the mail, and these offers will be for high interest rate credit cards. Terrible, terrible credit cards that if you don't know how to use them, you're just going to find yourself in the same situation a couple of months down the line. But yes, your credit actually does, in practice, start to improve immediately after the filing of the bankruptcy. However, for example, in a Chapter 13, if you want to take out new debt, not necessarily open a new credit card account, but if you want to take out new debt, you need the approval, the permission of the bankruptcy court to incur new debt. In a Chapter 7, they don't mind much. But in a Chapter 13 setting, since you're supposed to be paying under this plan, any new debt you incur can have an impact on your ability to pay under the plan, so the court requires approval of any new debt that you take out.
Interesting enough, I had a client who was in a Chapter 7 proceeding, a very long one, and complicated one. I cannot get into details, but it took over a year to finish these proceedings, and during that time, he actually got 2 credit cards during the Chapter 7 was still pending, and he got 2 credit cards, which was a whole mess for the bankruptcy, but he did got it, so it's not impossible, it's just difficult. And honestly, I did not ask him the interest rate, I would assume it wasn't that good.
Probably high.
Yeah.
Most likely high.
So it can happen. You can still get credit cards, you can still get loans, they're just going to be very difficult.
As I said, in practice, it does occur. You get offered all these beautiful, beautiful offers for credit cards at a high interest rate, but you need to be extremely careful, because once you receive a bankruptcy, only works for debts that existed from the time of filing. It's as if time stops when you file a bankruptcy. Everything that came before it is what is at issue. Your financial circumstances as they existed as of the moment the bankruptcy is filed. So, if he incurs any debt after the bankruptcy filing, then that debt will not be discharged in, did you say it was what chapter?
It was a Chapter 7.
Okay, so
Yeah, whatever debt he incurred
After
was not
is not going to get discharged for some time because you are only allowed, we're going to use this Chapter 7 as an example. You're only allowed one discharge between two Chapter 7 filings every 8 years. So if you get your discharge in one Chapter 7 case, you will not be able to file another Chapter 7 bankruptcy and receive a discharge in that Chapter 7 for a period of at least 8 years.
That was another of questions
That's just one example.
that people had. It was like, can you file for more than one bankruptcy?
Unless the court says otherwise, which is very rare, you can file as many bankruptcies as you want. The issue is whether or not you are eligible for the elimination or discharge of your debts in that bankruptcy filing. As I said, from 7 to 7, 8 years. From 7 to a 13, 4 years. Then from a 13 to a 13, you can get another discharge in 2 years. And that's of course from the date of filing of one to the date of filing of the other one. It all depends on what chapter you file afterwards. But from a 7 to another 7, we're talking a long time, 8 years.
Yeah, that's a long time. Well, it's the same time that it will stay in your credit report.
About the same amount of time.
It's the same amount of time, yeah.
So
Just answering that, what about credit card repairs, loan elimination, all that you can see about fixing your credit? How does that work? Does it actually work? Is it advisable for someone to go over these, choosing these credit repairs, this debt settlement over a bankruptcy? What do you think about this?
realistically speaking, there are no guarantees when it comes to all this fancy terminology concerning debt settlement, debt repair, debt elimination. There's really no non-bankruptcy law that says a creditor needs to work with you to help you eliminate or reduce what you owe to them. That's what bankruptcy law is for. That's what insolvency law is for. It's a set of rules that dictate when a person can eliminate or reduce their debt. There is really very few non-bankruptcy, there's very little non-bankruptcy law that will force a creditor to help you out. The creditor is normally not your buddy. Sometimes it could be. I mean, when you take out a personal loan from a buddy and don't pay him back, well, you know, he may have been your friend.
Just to add, if you get a personal loan, you can include it in your bankruptcy as well.
You can. Those are normally
all
dischargeable.
your creditors gets included, and all those debts are dischargeable. So it's just a side note on this, because people might think that we're just talking about credit cards companies and loans and banks. No, if you owe money to your landlord,
that is also most likely dischargeable. Yes.
And
personal loans, business loan that you're a guarantor on. Yeah.
So, and talking about debt, how much debt do you need to file for bankruptcy?
In a Chapter 7, the limit is so high that no individual can realistically in one lifetime reach that limit in a Chapter 7. Chapter 13 does have lower limits, but they're for unsecured debt meaning debt that's not secured by, once again, car or a house or something, or furniture or whatever the case may be. The limit for unsecured, like credit cards, medical debts, that's around 400 something thousand. Don't have the exact number because it actually changes every few years. And the limit on the secured debt, if I remember correctly, is somewhere upwards of $1 million. But again, I don't remember off the top of my head the exact amounts. And the reason for that is very simple. I can't recall Well, I can't recall one client, but other than that one, I can't recall a single client that's ever come close to any of these limits, any of these debt limits.
What about a minimum? Do you need a minimum of debt to file for bankruptcy?
Absolutely not. You can file for bankruptcy, although I don't know any attorney that would recommend it. You can file for bankruptcy if you are indebted in the amount of 1 cent. There is no minimum.
I would definitely not recommend someone filing for bankruptcy with such little debt.
I think that may be considered a little bit of malpractice there, actually, if you find, because he's going to end up paying you more, being indebted to you more as an attorney, his attorney, or.
I don't usually have a minimum, but whenever a client just calls me and tells me, oh, I don't know, let's make up a number, like $5,000 worth of credit card, I would advise them like not to file for bankruptcy and try to resolve this issue, even though it's annoying, because it's so little that it's no worth to destroy your credit if you have this little amount of debt.
Yes, in 99% of the cases, I think 5,000 may be a little too low when compared to what it's going to cost them to eliminate that debt. This is in my professional opinion, and once again, it's an opinion. I don't think you should.
All this is an opinion.
Of course.
We are not creating an attorney-client relationship here. We're just trying to educate you and giving you our honest opinion about things and how we practice. So we're just trying to help. We're not creating attorney-client privilege.
No, that we are not. And most of this is being talked about very briefly and in
very general.
Very
general, yes.
But in my personal opinion, that's kind of professional. I don't think I've ever filed a bankruptcy for an individual that's owed less than $15,000. That's not indebted at least $15,000.
No, again, it's just destroying your credit, the amount of money, attorney's fees, the court costs, the actual work that you have to go through, and I mean, it's not worth it sometimes. That's why preparation is the key in bankruptcy proceedings. So another question that it was very popular from our listeners and the people who called the office is how long the proceedings last, like how long a bankruptcy takes to get resolved.
Well, as I said earlier, concerning Chapter 13, the plan that you propose, the repayment plan, the reorganization plan, is going to be between 3 and 5 years, and that's part of the law. Your plan has to be between, at a minimum, 3 and a max 5. Now, of course, with COVID, the maximum increased because people found themselves in a pretty difficult financial situation because of the good old coronavirus issues plaguing everybody. So they actually increased that maximum. But that's in a Chapter 13. Chapter 13s are long. They're not fast and hard like the Chapter 7. Chapter 7, you're usually done. If everything is done correctly as it should be, if you go at it with an attorney, you will be done in less than 6 months, about 6 months.
You're done. I have had both type of plans. I agree with you that usually it'll take between 6 to 8 months. That's what I'm being seen. But I did a Chapter 7 that it lasted over a year and a half. I am going to blame this on COVID, but it was a complicated case. And I also had one that lasted less than 3 months. We filed, we went to 341, and that was it. So.
And if it's done correctly, that's all you need. You attend she's referring to the 341 meeting, which should be the only time you have to talk to anybody concerning your bankruptcy proceeding that's not your attorney.
That was a topic that I was not going to, but since you mentioned it, explain to us, what is a 341 meeting and what do we do there, and why is it so important that we show up and talk to somebody in that place?
A 341 meeting is required under bankruptcy law. It is where you are basically interviewed and asked questions by the Chapter 13, the trustee overseeing the case. The trustee is kind of like an administrator for the court that, make sure everything's being done correctly. They're supposed to be impartial. They're not on the creditor's side. They're not on your side. They're supposed to be a neutral party. They're just there to make sure that everything is going according to the way it should under bankruptcy law, and to see whether or not you have accurately and completely given all the information that is required to the court under bankruptcy law. So basically your 341 meeting is for you to answer a few questions from the trustee overseeing the case, and to give your creditors the opportunity to ask you questions. That scares a lot of people.
I know.
But
realistically, no creditors usually show up for these meetings.
They really don't avail themselves of that right. 99% of the time, 99.5% of the time, no creditor shows up.
I have yet to come to a 341 where a creditor had to show up. Trustee, yes, and you have to answer all those questions, but not a creditor. I'm sure that if you ask a loan from your brother and you file for bankruptcy, he will show up for your 341. But credit cards companies, they usually don't.
Usually the creditor that shows up at the 341 meeting is the small creditor that's very angry that you filed for bankruptcy. We get back to these personal loan situations. Your buddy could come and ask you.
Your landlord definitely will come.
Maybe. But maybe the thing with landlords is that they're usually owed not that much money and they don't want to hire a lawyer. But if they're angry enough, I can see them coming, because the typical landlord is not an individual that owns 300 properties. Right. It's the poor guy, or not so poor guy, that owns that one extra property that he's trying to make a little bit of income off of. So yeah.
All right, so let's move to another of the questions. So this is a very common one, and again, this goes to the preparation of your bankruptcy. How much do I have to disclose in a bankruptcy proceeding? Like, how much do I have to show to court about my income, my expenses, my finances, my personal life? How much do I have to tell the court about me?
About your personal life, really not much. This is not something that's personal. This is really a numbers issue. And when I said it's somewhat dry, the bankruptcy court, in a bankruptcy proceeding, we really just want to know your financial status as of the date of filing of the bankruptcy petition. Now, what comprises your financial status? Well, your financial status is composed primarily of your assets, your debts, that's important, income and expenses, and a few other pieces of information. Now, what do you have to disclose concerning these 4 primary topics? Everything. You need to list all your assets. You need to list all your debts. Trust me, you want to make sure you list all your debts, because if you don't list some, they're not going to get eliminated. So it's in your best interest to list everything there. And with everything else, list all your sources of income, everything about your income, and everything about your expenses. Those are the 4 main ones.
Okay.
And when I mean everything and accurately, as accurately as possible.
Okay, so this is another popular one. The question is, do I need to file for bankruptcy with my spouse?
No. The short answer is no. Sometimes it'll save time and money in the long run, but no, you don't have to file with your spouse. Your spouse is their own individual, their own person.
Yeah, but a few of my clients get very scared, because when you're doing the preparation for the bankruptcy, one of these schedules, you have to disclose your spouse income and how much they contribute to your household expenses. And they always get scared, like, why is my spouse being part of the proceedings? Why I have to give this information? Because is it going to affect his credit score, his job, his work, or somebody's going to know? And I don't want that to happen. So explain to us, how does that work and how?
The short answer is, again, bankruptcy is mostly a numerical computation and proceeding. They're not interested in your spouse. They're interested in their numbers, their money. Yes, if you file individually, not jointly with your spouse, in some of the paperwork you need to file with the bankruptcy court, it will ask you certain questions about your spouse. They're not going to ask for the individual's name, who your spouse is. That they really don't care that much about that, but they do want to know what numbers they're bringing to the table. They want to know how much they contribute to either the income of the household or if they contribute to the expenses of the household. They want to know that, because that is important in determining whether your ability to pay back your creditors. That's the only reason they're asking about your spouse. They don't ask for names, really.
The credit score is not going to get hit. It's nothing is going to happen. They just need the information because it's part of your financials in your household. But your spouse,
Directly, the filing of one spouse's bankruptcy will not affect the credit score or the credit report of the non-filing. It's called a non-filing spouse.
I mean, if you file jointly, yes, of course.
Yes.
But if he's not included, then no. There's no.
No.
All right, I think this is all we have for the day. Is there anything else that you want to add? There's something else that I missed, or?
I think if I had to impress something, what I consider to be perhaps the one thing everybody should take from today's podcast, today's conversation, is that the success or failure, and there are many different levels of how you can fail with your bankruptcy. The most important thing or things happens before you actually file. So it's important to, if you don't know what you're doing, consult someone that does and make sure they spend at least 30 minutes to an hour with you, because it takes time to unwind, most of your financial circumstances, and a lot of these things are crucially important to the advancement of your bankruptcy and the successful completion of it. It's preparation and full disclosure before anything gets filed is the most important step you can take to getting rid of your debts in either chapter of bankruptcy. Preparation is key, and it takes time to get it done.
Have you ever been in court with a pro se filer? I mean, a pro se is someone who does the bankruptcy themselves. And I've been, and the judges are not that nice with people that don't know what they're doing. They don't know what they are doing.
As one judge I know, every time he pro se comes to court themselves, actually for hearings, is I can't give you any legal advice, because I'm the judge here. You have the right to represent yourself, but it's not recommended. And that's all he starts every time when there's a pro se present in the courtroom.
They're not very nice. And if you're missing any documents, any paper or something, the judge will hold it against you, even if you're not represented. So that's why it's so important in such a matter to be represented with an attorney, someone who knows what they're doing.
I think everybody's heard the phrase, ignorance of the law is not an excuse. And that is true for criminal law, that is true for bankruptcy law, that's true for every other law.
Well, Paul, thank you so much for coming in today.
Thanks for having me.
How can we find you? How can we hire you? How can potential clients reach to you? This is your time to sell your pitch.
Oh, well, again, my firm's name, my name, more importantly, is Paul Meadows, Esquire. If you didn't know that by now. I can be reached by phone very readily, 305-788-9881. Once again, 305-788-9881. I can be reached by email directly. That's another thing. I do everything related to my client's case myself. So you're not talking to
A paralegal and assistant. I do that too. Personalization, that's the key. That's the key of my firm. I like to know where my clients are and what they're doing.
Because something can get lost. You know how when you tell something to one person and then they slightly say something different to another person. The more times that happens, something might get lost in the communication. And communication between you and your attorney is very important.
My assistant does some work, of course, because I cannot handle everything, but conversations, it's with me. My clients speak to me because I need to have the conversation in the one-on-one. So you were saying that we can reach you by email?
Once again, Fidelis Law.
Yeah.
is the name of my firm, Fidelis Law. 305-788-9881, and that is the best way to reach me. If you want to shoot me an email, it's and this is long, pmeadows, that's pmeadowsbankruptcy, which is the abbreviation for Esquire, bankruptcy, the full word, @gmail.com. So once again, that's pmeadows, bankruptcy @gmail.com. But it's better just to call me. Much faster.
For my YouTube viewers, I'm just gonna write that down so it's easier for them. If you're listening to the podcast, then you can just rewind and get it if you wanna get in touch with Paul Meadows and Fidelis Law. And I strongly recommend that you do so for any of your bankruptcy needs. Once again, thank you so much for coming. Thank you so much for listening. Please share this podcast. Send us your questions. If you need more information, we are in YouTube. We have a blog. Everything is under Morejon Attorney PA. You can find us YouTube, Instagram, TikTok, Twitter, Facebook, everywhere. We're everywhere. We have our website, morejonattorney.com. If you have any question, you can always reach us at 786-907-0154. If you need our services, you can more than welcome call us and schedule a consultation. Thank you so much for listening, and I hope to see you in the next episode.
Thank you for having me.